26, when we arrived, we were then given permission by the ID to go and assist in court. When we arrived at court, we found Advocate Tlhatjwayo in the company of the investigating officer, Mr. Padayashe, and evidently overwhelmed. The court was about to commence, and the J15, which is the administrative form to which the charge sheet is attached, had not been completed, there being some 7 accused involved in the matter. Advocate Vedboy obtained the necessary J15. I remember she literally rushed to the clerk of the court, brought a blank form. I then took the docket from Mr. Padayashe. I then started reading out the names of the accused as they appeared in the docket to Ms. Vedboy, who was then, to Advocate Vedboy, who was then completing the J15, which was then handed to the clerk to register the matter on the book. Our assistants enabled Advocate Tlhatjwayo to consult with the defense legal representatives. The courtroom was full of police officers, family members of the accused, and members of the press. Advocate Vedboy and Shikovi obtained seats at the back of the court. As there was nowhere else to sit, I then sat in front next to Advocate Tlhatjwayo, and Mr. Padayashe, the investigating officer, was seated directly behind us. I was not the prosecutor in the matter. My colleagues and I attended solely to support Advocate Tlhatjwayo. The proceedings commenced before the magistrate, Mr. Matlangu, whom I did not know and was seeing for the first time. Advocate Tlhatjwayo conducted the bail proceedings on behalf of the state, indicating that the state was not opposing bail and setting out the reasons. The legal representatives of the accused moved their bail applications by reading their client's supporting affidavit into the record. At various points, Advocate Tlhatjwayo experienced difficulty in answering questions from the court and conferred with me and with Mr. Padayashe, who was seated behind us. In the course of dealing with the bail application, Advocate Tlhatjwayo asked the court to impose a condition that the witnesses not be contacted or interviewed by the accused. The magistrate indicated that he required a list of the witnesses, as he could not simply warn them, and he appeared not to be satisfied with her response. The magistrate then invited me to address him, observing that I appeared to be from the same office. And maybe just to add here, Commissioners, I remember he precisely said, because they were engaging with Advocate Tlhatjwayo, and he then looked at me and he said, okay, let the gentleman seated next to you address me. He appears to be from your same office, because now and then Tlhatjwayo kept on let the gentleman address me. Before doing so, I then asked Padayashe whether a bail statement or affidavit had been prepared.
What is a bail statement? What would you find in there?
Commissioners, this matter, as I understood at the time, fell under Schedule 5 of the Criminal Procedure Act. And Schedule 5 and Schedule 6, these are serious matters. Schedule 5, the accused to be released on bail has to bring an application and satisfy the court that it is in the interest of justice that he be released on bail. What we do as the state, to avoid the investigating officer to testify viva voce in court, he then compiles an affidavit setting out even if the state is not opposing, the reasons why we are not opposing. For example, we would have verified the addresses of the accused. The statement will state, we've checked their criminal records. They don't have criminal records. They are not a flight risk. They are gainfully employed, and all those kind of issues, they will come into the statement. We either do that by way of an affidavit of the statement, or the IO has to go into the box, and as a prosecutor, I'll then have to lead him to cover all those aspects.
And you say that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state, at least by way of an affidavit from the IO or so. And I do not have case law with me, but I know there's a case or two where the court would have also said, even when the state is not opposing bail, but the court is sitting, the court needs to be assisted by the two parties. And even when the state is not opposing bail, but you, as an officer of the court, you have to address the court, say why you are not, give this information to the court. So if you have compiled an affidavit, it's easier for the court. You read it into the records saying these are our reasons. And when the court evaluates whether or not the accused has met the onus of proving that it's in the interest of justice that he believes on bail, the court has the benefit of both the state and the applicant's evidence. But in this case, the bail application or the statement was not done, which was one of the things that made me realize that this team did not appear to have been ready for this bail application. I would have expected them to, because when we were in court, I then asked Brian, just before addressing the magistrate, I asked him, did you compile an affidavit? Because now I could see the magistrate was going to engage me. So I wanted to speak out of an affidavit, not just give the court information which I was not privy of. But I remember asking him about the issue of the list, and then quickly he said, no, we have other outstanding investigations against some of these people. So that is why we don't want the list of these people to be known, because if we list them, that's going to impact on our outstanding cases. And that is what I then delivered to the court. I'm at the paragraph where the magistrate invites me to address him, and before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared. It had not. Mr. Padayashi explained that the witnesses had been told that if they were contacted by the accused, they should immediately report to him, so that there was no danger in that regard, and that there was a further ongoing investigation involving the same accused. Such listing of the witnesses could disclose their identities and the existence of that other investigation. This is what I delivered to the court. On that...
Sorry. So where you say in line 1, 2, 3, 4, 5, there's a sentence that starts, so that there was no danger in that regard. It's preceded by where Padayachi explains to you that witnesses have been told that if they are contacted by accused, they should immediately report it to him. And then you say, so that there was no danger in that regard. Can you just explain what you're addressing there?
Yeah.
Where you say, so that there was no danger in that regard.
Yeah, I think what I wanted to say here was that Padayachi and his team would have discussed with the witness to say, if anyone contacts you, please let us know so that they can take steps. So I'm saying, so that there was no danger in that regard. The quicker they are alerted, the investigating team is alerted, then the danger could be averted.
Okay.
On that basis, at paragraph 31, on that basis, I then addressed the court and requested that the witness not be listed, so as not to compromise the other ongoing investigations involving certain of the accused. Out of respect for the court, I could not decline to address the court when the magistrate invited me to do so. At 32, bail was fixed for the accused in the amount of 10,000 rand each, save for accused number 2, Mr. Lushaba, who was not admitted to bail at that stage owing to a separate outstanding matter, and the matter was postponed. Among the conditions imposed by the magistrate was a condition that the accused do not enter the premises of crime intelligence anywhere in the country. Neither the state nor the investigating officer had requested that condition, and the magistrate gave no reasons for imposing it. Of significance is that in the course of granting bail, the magistrate himself remarked that he was not persuaded that the state had a strong case, and indicated that these was among the consideration that moved him to admit the accused to bail. He observed that the matter was not a typical fraud or corruption case. This doubt was expressed by the presiding officer at the very first appearance. It's there on record, Commissioner. The magistrate says it after asking Advocate Tlajwayo some questions. He says, I'm not that convinced that your case is that strong because it's not like the typical cases that we deal with of fraud. And he also says it to the accused when he grants them bail. He says one of the things that I've considered is this issue, and I'm not convinced about the strength of the state case as it stands, based on the address by the prosecutor. The record speaks for itself on that issue. 34, my involvement then ended after the first appearance.
Can I just ask you, so you stayed in court the whole time until the court rose?
Indeed, Commissioners, I stayed in court until the matter was, the bail application was finalized.
And where was Mr. Padiachi by the time court rose?
Mr. Padayashi was with us up to a certain point, I think just before the judgment, because he had to catch a flight back to Durban, Port Elizabeth. He's based there, he stays there, so I think he comes to the office after every second week. There's an arrangement that they have in the office. So I remember he had to go back, rush to airport to catch a flight. So he kept on saying to us at the time, guys, I'm going to leave you. I'm not going to stay until. So he left at some point. When the magistrate was delivering judgment, he was no longer there, he left.
More specifically, when the debate or discussion about conditions was happening, do you recall whether he was in court or not?
He was still in court, because I also asked him, that's when I asked him, do you have a bail statement? Have you prepared a bail statement? And when Tlajwayo was addressing the court about the conditions, he was still there. I think he left just before the magistrate had started delivering judgment.
Thank you.
Yes.
Advocate Serunye, before you move to the 8th to August, when you come back from court and having seen what you've seen that day, from the moment where you were consulting your colleagues to what you've then witnessed in court, did you do a report to either the ID or Mr. Sisoko on the developments of the day? In particular, your concerns.
Yeah. Personally, I did not, because at least at this stage, I did not have enough information that I later got. At least at this stage, in my mind, I'm thinking there's a team that is dealing with this case, but it's strange that only one prosecutor and one investigator are in court, and the DPP that I expected to be involved in this does not seem to know about this case, because he's not with them, and I saw him in the office. But, you know, and I could see that they were not ready. There was no bail statement. But after that, my involvement literally ended there. And what we do in the office, when I would have expected Advocate Tlajwayo to do the reporting to the ID. That is what we do when come back from court, especially in this type of cases. This was a very big case. I mean, generals in the intelligence service, you know, one would have expected a report to be given to the ID to say, this is how we fared, this is what happened, and the case has been postponed to such and such a case. Personally, I did not, at least at this stage, I did not make any report because I was not part of the case. My involvement was to help on that day, and I think I did my level best on that day, and that was the end of it.
Suppose the question is, I understand the report as it relates to what happened in court and where it landed, where bail was granted, conditions, and all of that. But in this instance, what you knew that day was that there was no DD, there was no senior prosecutor. They certainly didn't appear to be ready for the bail proceedings. You had to step in as somebody who's completely not involved. this was run by the most junior prosecutor, you say, at the time. It seems to me that beyond the reporting about the progress of the case and what happened in court, there was other issues related to how the matter was being conducted that ought to have been reported.
True. But remember, I'm not designated to the team formally in terms of the relevant provisions of Section 28. And secondly, we have these non-disclosure forms that we complete. So I cannot go beyond trying to find out even about the facts and getting myself involved that much. My request on the day to the ID was to be allowed to go and help in court, and that was granted. So I couldn't go beyond that unless I was designated formally into the case. You know.
But the concern is that you knew that there was no DDPP and there was no senior investigator, and that your junior prosecutor did not have sufficient support. That's why you had to step in at the last minute. Now, what you are saying here is after court, you left that there. So in other words, if there was going to be further appearances or further investigations, she would still be doing that unsupervised without a DDPP overseeing her work.
Commissioner, at the time, yes, but like I said, the name of Advocate Ramsemi also was thrown in. So somehow I know that she's also part of the case. I was told that morning she was off sick.
But she's not a DDPP.
No,
you said in paragraph 20 and I think 26 that the DDPP must head every matter and they are the project owner.
That's true.
So this matter was proceeding without a DDPP and a project owner. Because even if Advocate Ramsami was assisting Advocate Tlachwayo, it would be two junior prosecutors. Was that not a concern for you? For such a big matter, we're talking head of crime intelligence in the country and other generals at SAPS.
Commissioner Kumalo, it was a concern, and that is why I asked to go to court to assist. But I did not think of involving myself beyond that that point after the bail occasion was done, because I did not know why is this team so small. I did not know how it came about, but what I know is a case cannot be handled or done in the IDEC without the ID knowing. Therefore, I don't know how this team was composed, but honestly speaking, I didn't want to get myself involved in why was this done, why was not, because I was not part of the team at the time.
You give the impression that you did not want to step on the ID's toes. You did not want to ask her difficult questions. So you said, if she made the decision, I will live with it. I won't even question it. That's the impression you are giving me.
And I'll agree to that, Commissioner. Because as the head of the office, you would have made decisions. I can't ask questions on, especially questioning how this team was composed, why not involve me, or why not involving Advocate Polo, who was overseeing this. I at the time, I didn't ask myself many questions on the composition of the team, but it didn't look right to me that a case of this magnitude was on the day of the arrest.
Sorry, you say in paragraph 34 your involvement ended after the court appearance, but I don't think you mean end, because in paragraph 35 you say you were called to a meeting on the 8th of August, and at that meeting the ID informed you that she had decided to include you in the matter. So it was not end forever.
That is correct, Chair,
So there was an intervening period during which you were not involved. That is after the court appearance in June. And then in August, you were brought in by the ID herself.
that is correct, Chair. I'm saying my involvement ended there with the bail application because I was not part of that team. I was not supposed to be part of the team. I went there and helped with the bail application, and my involvement in as far as they ended there.
Yes.
But
Only in
coincidentally, about 2 weeks after, then I'm called for a meeting where I'm formally then involved or designated by the ID into the matter. After the bail application, I did not work on this case. I did not discuss it. I continued with my work. I'm overseeing a group. I'm also having my own cases. I'm doing it. I concentrated on my work. I forgot about this case until on the 8th when I was called to a meeting by the ID.
The 8th of August.
On the 8th of August, and which is then on paragraph 35, on or about 8 August.
Maybe before you discuss, you go to paragraph 8, let me ask my question. And again, it goes back to wanting to understand the reporting and role of Mr. Sissoko. You have this experience now on the 27th of June, and you note all these wrong things about it. Isn't that typically something that would have had to go into the discussion? Because part of it sounds like resource allocation, right? Isn't that something that would have typically gone into the reporting to is it OMC or something, when you make those monthly reports and get it addressed there? Is that not?
I agree, Commissioner. It's something that ought to have been raised in that structure. I'm not sure if it was at a later stage, but from the date of the bail application when the case was postponed until up to the 8th, I don't remember. I don't think we had an OMC. But these are type of issues that are dealt with in the OMC. Resource requirements, where there's shortages, and even these challenges that how is a team dealing with such a big case and there's no deputy.
So you say you don't remember whether it was raised or that you had a meeting after that. Is that?
That is correct. Between the 27th when the case was in court and the 8th of August when I was involved in the case. But then from the moment I was involved, and the commission will see, as I'm calling meetings of this team, I'm also copying Mr. Salk. I'm involving him in the matter.
And where is Mr. Lowe in all of this by the time you get called on the 8th of August and you are now told this is your matter? Where is he?
He was never involved in the case at all, Commissioner. He was not part of this case at all. Ever? Even though the type of case resided in the group that he was overseeing, but he was never involved. He was not designated in this case.
Okay, thank you. And do you know why? Did you ever get an explanation, even informally, why you are the one that's been called on the 8th of August and he's not involved?
I did not ask why, but as I'm going through my statement, Commissioner, you'll see that I take it when I was called in, maybe it might have been the ID got, like I left the message with a PA, and she then gave a go ahead.
Okay.
Maybe because I helped on the first day. Let me. I nearly said Somar. Let me proceed with Serunye because he helped on that day. I think
you could have said Somar. We've had worse.
Yes. So I believe she involved me and not him because I went to help on the first day, and because when she called me on the 8th, she said, I've decided to involve a DDPP in the case, and I want you to be part of it.
Okay, thank you.
Yeah.
All right.
Just to correct you on the intervening period, you said that after the court appearance, you were not involved until the 8th of August, 2025. when you were called to a meeting and told that you would be included in the matter. The court appearance was on 27 June.
27 June.
Yes, 2025.
I'm very sorry,
You said,
Commissioner.
you said the intervening period was 2 weeks, so it was over a month.
It was over a month.
Yeah.
I'm thinking the appearance was on the 27th of July. It was actually on the 27th of June.
Yes, all
Yes,
right.
that is correct.
And just to add an important fact, it may or may not be relevant. Between the court appearance and the 8th of August, 6 July happened.
Indeed, Commissioner, the address to the nation by the general, is he a general? By, yeah, Mr. Mkwanazi, that happened. And that was in July. That was in July, yes. That happened, and I must say, I remember watching, I was home that Sunday, I remember watching the press conference as he was briefing, and then he mentioned this case. And I thought, how come, I didn't really, you know, I thought, you know, for the moment that I was in court and left the court, much as I didn't know what happened before, I didn't see anything sinister that when he mentioned the case and how it was handled, and that to be honest, I doubted his remarks at the time. To put it bluntly, I doubted his remarks at the time about this case, and for the longest of time I did. And until now, recently, in the last maybe 2-3 weeks of the evidence that we had in this commission, that's when I started realizing maybe, and I said it to one of our colleagues even this morning when we were having tea, that it appears I sort of found myself in an offside position, or at least handled a ball with my hands. In fact, I sort of feel a little bit angry if I think about it, that it feels like I was set up, not only me, but Tlhatswayo as well. I think junior as she was, I don't think she was supposed to have been involved in this case. And looking at it now, it appears to me she was set up.
But I think you are being unfair to yourself. You are still going to come to this later in your statement. You have placed before us an annexure in which you actually questioned the merits of the case, and you prepared quite a lengthy document raising a number of concerns that you had about the merits of the case itself. Of course, I'm sure that what you are talking about now is possible impropriety with regard to why the case was investigated in the first place. I'm sure that's what you are talking about. But it's not as if you just gobbled up everything, every and anything that was placed in front of you.